Diddy was in court today for what he is calling a violation of his constitutional right to privacy because he's claiming that the government raided his jail cell pretty much illegally and collected information that he was going to use in his defense for his criminal charges brought against him for the sex trafficking and the conspiracies and everything going against him. Now, he is saying that this is a violation of his constitutional, can I not say constitutional, was constitutional rights to privacy. Basically, they violated his Fourth Amendment right, his Fifth Amendment right, and his Sixth Amendment right, including his right to counsel, and basically saying that they violated his attorney-client privilege as well, because allegedly the prosecution went through notes that were protected by the attorney-client privilege because it was communications between him and his lawyers, and then also he's claiming that their work product protections over those documents because they were notes that he was taking in anticipation of litigation and in order to help his attorney out. Now, Diddy will be in court on Friday to discuss his bond hearing yet again. This is going to be his third attempt trying to get out on bond, and he's essentially alleging that he cannot properly prepare for this case that is supposed to take place at the beginning of May of 2025. So just a couple of months here. We're talking like 6 months or so for him to be able to prepare for this case that has terabytes and terabytes and terabytes worth of information that they need to sort through in order to prepare a valid defense for him. Now, we will not be going over that today because we will be going over it tomorrow. So if you're new here, make sure you go ahead and subscribe so that we can talk about what Diddy is saying he needs or what Diddy is saying as to why he qualifies to be out on bail, because there are some other people that are being accused of some similar things and they're out on bail, and Diddy's basically like, well, why am I not out on bail? And we're going to talk about that tomorrow. But first, today, we are going to get into what happened. Why did we have this emergency hearing right before the bail hearing on Friday? What is the prosecution being alleged of doing, and what the judge ultimately determined whether Diddy's constitutional rights were actually being violated, or what other remedies could come of effect other than basically getting rid of the entire criminal charges against Diddy, which of course he would like because he does not want to be facing going to jail. Now, if you guys have been watching the last few live streams, you know that we are going to go through the docs first, talk about what's going on, and then I'll jump into chats afterwards. I do not have Kimmy backstage with me today, so I will try to keep the most relevant comments, but anyways it goes. We'll get to that at the end of the live stream. Let me know what y'all think. Let me know if you've been watching and keeping up with everything that has been going on so far, or whether this is new information for you. All right, y'all. So we have Diddy filing an emergency order, I believe late last week, or maybe it was this week, filed a request for an emergency hearing indicating, I think it was actually yesterday. Yeah, it was yesterday. Emergency hearing. Sorry, y'all. Filing a motion for an emergency hearing because apparently way back in October 28th, 2024, there was a raid throughout the entire jail, and Diddy's cell happened to be one of the ones that was also raided. The defense learned in the response, we talked about that bail motion we're going to cover tomorrow, and the prosecution's response as to why they don't think that bail should be given to, sorry, y'all, I got something going on my thingy here. I don't know what's going on with my screen, but sorry that it kind of jumped into the middle of what I was talking about. Okay, it went away. So anyways, the defense is filing this ex parte motion. Basically, I need an emergency hearing and getting in front of the judge because of information that the defense learned from the prosecution's response to the fact why they don't think that Diddy should be let out on bail. Again, we are going to cover that tomorrow, so we're not going to go into the details of what was really put in that document and what Diddy's position is regarding him needing bail. Essentially, in short, they're basically saying that they obtained information from that raid. They raided not everyone's cell, but a lot of people's cell in the entire jail to basically try to get rid of contraband, drugs, anything illegal that you're not supposed to have in the jail in order to guarantee the safety of the prisoners. and also the safety of the staff. This was not supposed to be a raid. This is the defense's position. This was not supposed to be a raid to go through Sean Combs, Diddy's stuff and find out their strategy for the lawsuit. So let's go ahead and jump into their opening letter explaining to the court why they need to have this emergency hearing and requesting this emergency hearing, and what information does the prosecution have. They need to know this. They need to know who authorized this. They need to know what's in there and whether they have any attorney-client privilege. And the defense's position is if they do have any attorney-client privilege, then some sanctions need to be going on, and potentially the case needs to be thrown out, which they actually didn't ask for, but I'm just kind of throwing that in there. That hearing was actually today, so we do have a decision from the judge. So let's go ahead and jump into what the documents actually say. And bear with me, y'all, because my computer is on some weird stuff and I can't really pull up the documents how I normally do. So this is what we have. We have the defense writing to the judge saying that they recently learned that the prosecutions are in possession of attorney-client privilege material, including the defendant's own written notes. And why is that important? Because they're going to claim that it's work product privilege, meaning that they're making notes and this is going to be our strategy. And the prosecution cannot know that. They cannot violate Diddy's right to his attorney, his right to establish a defense. They're not privy to all of that information. So they're saying, we think that they have this information, and here's why. This search and seizures are in violation of Mr. Combs' 4th, 5th, and 6th Amendment rights. Moreover, the targeted seizure of the pretrial detainee's work product and privileged materials created in preparation for a trial. He's taking notes of the conversations that he is having with his attorneys. So he is saying that this is work product material. He's basically, or the defense is saying this seizure of these documents is outrageous government conduct amounting to a substantive due process violation because the prosecutors are currently in possession of privileged materials and are actively using this material to detain the defendant. The defendant requests an immediate evidentiary hearing. This is an emergent matter because the government has Mr. Combs' privileged notes to his lawyer concerning defense witnesses and defense strategies. The government's opposition to defendant's bail motion states that the trial prosecutors are currently in possession of possibly privileged materials, such as the notes recovered from the defendant's cell. I have not read that part in their statement. So I would like to see that if they really put in there that this is possibly privileged information, you can't be holding on to that, dude. This is a matter of grave concern that most respectfully must be addressed immediately for the following reasons. First, there is no dispute that the government is in possession of privileged material. I think there is a dispute whether they're in possession of privileged material. You're saying that they put in there that they have possibly privileged material, but that kind of creates its own dispute of they don't really know whether it is going to be considered privileged or not. So there is a dispute there. But one thing that I have noticed about Diddy's attorney, just in reviewing a couple of the most recent documents, he likes to make very absolute statements. And that's one thing they taught us in law school not to do. Don't write, clearly this is a violation. There is no dispute, absolutely no dispute. You're not supposed to use that kind of language. I forgot the reason and why, but it's probably because, like he said, there is no dispute. There is a dispute, sir. Clearly this. No, that's not clear. You don't tell the judge what to think. So let's go ahead and jump back into it. So he said, first, there is no dispute that the government is in possession of the privileged material. Second, until receiving the government's submission at 11:30 or 11:29 p.m. on Friday, November 15th, the defense had never been told that 1, Mr. Combs' notes were taken from his cell, and 2, that these notes were given to the U.S. Attorney's Office, and 3, these notes were then given to the trial prosecutors in this case, who then used the material in a filing to keep Mr. Combs detained. This is what they are requesting from the court and from the prosecutor. We request an immediate hearing and that the government shall provide answers to the following questions. First, who authorized a search of Mr. Combs' sleeping area, personal effects, and paperwork? Second, who determined the paperwork to take? Third, who decided to give this paperwork to the United States Attorney's Office? Fourth, who decided to give this paperwork to the trial prosecutors? Fifth, who made the decision to not tell Mr. Combs' counsel that the U.S. attorney was in possession of his notes, including possibly privileged materials, including after the government put them in a filing to keep him incarcerated? Six, exactly what material was taken? Because the U.S. attorney and it seemed the trial prosecutors are currently in possession of privileged materials, we request a full evidentiary hearing as soon as the court can accommodate us. So, like I said, they're putting all this stuff on the record, in my opinion, to potentially get the case dismissed, but they aren't actually asking for the case to be dismissed, I guess, until after they figure out what all does the government have? What did they have access to? Did they get into any of the privileged communication? Now, are these questions written the best? Not in my opinion, but we will go ahead and go on to what the prosecution has to say. Of course, we know what they're going to say. We don't have any privileged information. We don't know what the defense is talking about. Do they specifically answer any of their questions? No. I'm just going to be straight up with you guys. No, they don't answer their questions specifically. They kind of go about it in a roundabout way. So let's go ahead and jump into that. Alrighty. So we got the prosecution. Defense has asked, hey, what did you take? Why y'all didn't tell us about it? Whose decision was this? Why are y'all going through our client's stuff? They asked 6 questions, but all in all, that's basically what they're asking. The prosecution says, no. There's no issues here. Why are we here, Your Honor? Because the defense has no clue what they're talking about. So defense filed a request for the emergency hearing yesterday. The prosecution was required to respond by the night, I guess, 11:59 p.m. yesterday, and then they had the hearing today. So they got their emergency hearing as requested, but the prosecution stated that the emergency hearing was not really necessary. But with the directions given at the bottom of the defense's request, they should have known that they were going to have the hearing anyway. So just saying that it's not necessary, I think, was stupid. But either way it goes, let's go. The prosecution says the government respectfully submits this letter in connection with the defendant's letter dated November 18, 2024, and in response to the court's order issued earlier today. For the reasons that follow, the relief requested by defendant included in evidentiary hearing are unnecessary. So they're saying they don't need this hearing, but as I already stated, the court already scheduled the hearing, so you're going to have it. You're going to have it. But here we go. The background. On or about September 16, 2024, the defendant was arrested. The following day, the above referenced indictment was unsealed, and the defendant was presented arraigned before the Honorable Robin Tarnbowski. Let's see. As part of the proceeding, the government moved for the detention under the Bail Reform Act, finding that there was no condition or combination of conditions that would assure the safety of the community. I don't know how to say that name. We're going to call him Judge T, denied the defendant bail. The following day, the Honorable Judge Andrew Carter heard the defendant bail appeal, and after a lengthy hearing, determined that the government had proven by clear and convincing evidence that the defendant was a danger to the community and a risk of obstruction. So let's get into why they're saying Diddy is a bad boy. So remember, we are having the bail hearing on Friday. That's when that hearing is going to be held. But the prosecution takes it upon themselves to take this as an opportunity to give the court information about why they don't think that Diddy should get out on bail, in support of the reason why they took the information. But also, I agree with the defense that they contradicted themselves and said, oh, well, this investigation was not triggered or targeted towards Combs, but also Combs has been doing bad things, so we were justified in taking the information. Yeah, I agree with the defense that this is a little bit contradictory, but let's get into it, because Combs has been a bad boy. Since being ordered detained, the defendant, also known as Diddy, has been held at the Metropolitan Detention Center in Brooklyn, a Bureau of Prisons, which they're going to refer to as BOP or BOP, depends on what I feel like saying. We'll call it BOP or BOP. With respect to the inmate communications, all BOP inmates, including the defendants, are afforded the opportunity to confer with attorneys on unmonitored phone lines. Other communications occur over BOP monitored phone lines and email. As part of its general practice to screen monitored communications for content that could jeopardize the public or the safety, security, or orderly operation of the facility, BOP staff, including a particular BOP investigator, who is going to be referred to as Investigator 1, has consistently monitored the defendant's communication on monitored communication channels, including monitored phone lines. This monitoring is independent of the case team, with the Assistant United States Attorney charged with the investigation and prosecution, and is not done at its direction. Basically saying there is this individual investigators who has been watching Diddy, and he's also the person that ends up raiding Diddy's cell. So are they on the prosecution's team? Why did they give them the information? Why did they take pictures of notes if they were just trying to maintain the safety? But also, I guess it does make sense that they're trying to maintain the safety. And if Diddy is doing what the prosecution is going to accuse them of doing in this ex parte response, then I guess that could go to the safety of people outside of jail, but not necessarily the people in jail. So let's get back into it. As set forth in the government's November 15, 2024 brief and made clear on this record during the previous bail hearings, the government's grand jury investigation of the defendant, including the defendant's obstruction related to this criminal case, is continuing. As part of that investigation, the government has sent grand jury subpoenas and documents requests to BOP for the defendant's monitored communication, including calls and emails. Now, what the defense is saying that they took notes. The prosecution is admitting that they are monitoring his emails and calls. That does not include his notes. So let's see how they get out of this. From those materials, the government have learned that the defendant has persisted in engaging in obstructive conduct since he entered the BOP custody. Among other things, the defendant has engaged in unauthorized communication practices, including a three-way calling on the monitored phone lines, 2, use of other inmates' phone access numbers to make phone calls on the monitored phone lines, and 3, use of third-party text message provider through the BOP's monitored email system. Each of these methods of communications is prohibited by BOP. Further, as set out in the government's November 15, 2024 brief, the defendant used these unauthorized methods of communications to continue to engage in obstruction, including by instructing third parties to reach out to witnesses and attempting to influence the jury pool in the criminal case. Now, we are going to get into the defense's responses to these allegations, but they don't really address it. they do not really address it. They don't say if he's doing this or if he's not doing it. But Diddy. If this is true, why are you doing this? Why are you trying to get over on the system and get your communications across by using other people's numbers? If this is true, right? I don't think that's going to help your release on bail. And I think that the prosecution strategically poked this into this part of into the ex parte. I don't think it was really necessary that we got all of that information in this, but basically they're saying they're recapping their brief. But Diddy, you can't. You just can't do that if you're going to ask to be out on bail and you're promising that you're not going to tamper with witnesses, but you're tampering with witnesses in jail. It's going to be easier for you to do it outside of jail. And for those of you that missed the beginning of the live stream, we are going to be talking about the bail motions and their positions tomorrow. The defense should be giving us a rebuttal tomorrow, so we should have a little bit more information on it. That's why we're not covering it today. So Diddy is being accused of doing three-way calls, which he's not allowed to do. He's being accused of using other inmates' phone access because they need to track who's calling who. He's being accused of that. And then he's also being accused of using third-party text messaging providers. So he's allegedly doing things he's not supposed to be doing. Okay. The defendant has used all three of the aforementioned methods of communication to communicate with his attorney. So not only is he using the monitored line or the unmonitored lines, which he is allowed to do, he is also using these illegal ways, the using other people's phone lines, doing a three-way call, and also doing the text messages. they're saying he's used all of those 3 methods. So I guess they're trying to hint at he's waiving all of his attorney-client privilege because he is violating the BOP rules. I don't think that's really a strong argument, prosecutor. Accordingly, although it is clear to all parties involved that these calls and emails are monitored, in an abundance of caution, the government sent any potential privileged communications, any communications involving an attorney, to their filter team for review before it was released in the case to the case team. I'm laughing, and I'll bring it up when we get to the defense's response of why I'm laughing. So remember, the prosecution is referring to this team as the filter team. So remember, prosecution is calling it a filter team. It goes to them before they get the information just to make sure they aren't tainted in getting any attorney-client privilege or any work product. Although someone in their office might have seen it, the people on the team has not seen it. And we call it like building a firewall, an imaginary firewall. So this person in the firm can see it, but other people cannot. And the prosecution is calling it the filter team. And just listen to what the defense calls it once we get to their response. So, okay. So as the government's longstanding practice is ongoing covert as is the government's longstanding practice in ongoing covert investigations, such as the investigation into defendants' obstructive conduct in the MDC, the government did not disclose potentially privileged communication to the defense counsel on the first instance. The defense counsel wants to know why. Why? Because you guys are still investigating, going to the grand jury. I don't know if that's an excuse. I really don't know if that's an excuse with a case already open. As stated in the government's opposition to the defendant's bail motion, the government intends to produce all defendants' calls and emails in full to the defense counsel today. So basically, they're saying, defense counsel, you're jumping the gun. Literally, it was just the weekend, and now you're following this motion, and we were going to give you the stuff anyways. But also, they're saying, I'm going to give you the stuff anyways, but it's like 11:29 at night. So I just kicked myself out of the live stream. Oh my gosh. Sorry, BriHive. I can't breathe. I'm very much so sorry. I really just kicked myself out the live stream. That's awkward. That is really awkward. Where's my stupid screen? Okay, we're back. We are back in action, y'all. Back in action. Sorry about that. Okay. So the sweep of the MDC, they're going to give us a little bit of background of how we ended up in this position. Why was Diddy's cell raided? Okay. So they gave us some background. Let's get into it. In or around October 28, 2024, the BOP and several other federal and local agencies initiated a sweep of the MDC. The sweep was pre-planned and coordinated to ensure the safety and security of the staff and inmates at the MDC and was part of a larger safety and security initiative and not in response to any particular threat of intelligence. Now, I will point out safety and defendants' papers. I don't know if that's going to protect the staff and the inmates. I'm with the defense on that. I am with the defense on that. The MDC sweep included the jail and the warehouse where MDC food and other properties are stored. It was planned well in advance of the defendant's arrest and was not conducted to target any particular inmate, including the defendant. So basically, this is something that is being done by the actual jail, and the prosecution has nothing to do with it, is basically what they're saying. During the MDC sweep, multiple housing units were searched, including the defendant's unit. Although members of the case team were aware in advance that the defendant's housing unit would be searched in addition to other areas of the jail, no one on the case team supervised, conducted, or participated in the search of any housing unit, nor the search of defendant's bunk area. In fact, the case team was not aware in advance of what agents and officers were conducting the search of the housing area. Investigator 1 was assigned by BOP to participate in the week-long sweep and was present at the MDC during the operation. During the sweep of the defendant's housing unit, Investigator 1 interviewed multiple inmates, including the defendant, about potential corruption and contraband at the MDC. Following Investigator 1's interview of the defendant, Investigator 1 approached the defendant assigned bunk to check for contraband. On the defendant's bunk, the Investigator 1 found the following items: a manila folder marked legal, a notebook labeled, they blank it out, marked, let me see, with respect to a notebook, a notebook labeled blank, an address book, and personal effects. Sorry, y'all. Investigator 1 felt the outside of the manila folder marked legal for contraband, and feeling none, set it aside and did not open or photograph it. Now, the defense's argument regarding the folder is fairly interesting to me. Remember, the prosecution is saying that the manila folder and all these other documents were found on defendant's bunk. When we get into the defense's response to this, they're going to say that it was in a locker stacked on top of each other. So the prosecution or the investigator should have known it all was legal stuff. I'm not buying it, but we'll talk about it more once we get there. So he felt on the manila folder and probably felt that it was just papers there. So he didn't feel a need to go through it. That's what I'm getting from that. Blank and the address book, Investigator 1 took photos of these materials. Investigator 1 left the materials on the defendant's assigned bunk. No physical materials were seized from the defendant. So all they did was take pictures of what he thought was going to be important. Following the MDC sweep, Investigator 1 alerted the case team that he had taken photos and that defendant's blank notebook and address book, the photographs that they're referring to as the photographs. Investigator 1 described the blank notebook as largely notes to self written by the defendant that included notes regarding blank. We don't know what they're saying was in there. In an abundance of caution, the case team asked Investigator 1 to provide the photographs directly to the filter team, given the possibility that they touched on legal strategy. Following review, the filter team provided certain of the photographs to the case team, including photographs containing redactions. So the filter team went through everything, and the state is saying they redacted everything that was what they would consider to be privileged communication, or maybe even work product. They're taking notes on what their defense is going to be. Now the prosecution gets into attacking the defense's filing of this motion. On November 8, 2024, the defendant submitted a renewed motion for bail in front of Your Honor. In the government's response filed on November 15, 2024, the government argued, among other things, that the court should deny the defendant's motion to reopen the bail hearing since he had failed to present any new or material information. In addition, the government argued that the defendant was actively continuing his efforts to obstruct justice while in custody, including by, among other things, attempting to influence witness testimony. Now, if that is true, they can use those emails and those phone calls, right? Remember, we got that on Donald Adelson when she was calling and talking and saying she wanted to flee the country and everything. We got that on Hannah Gutierrez Reed when she was like, haha, I shouldn't be in here, blah, 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 whatever it is that she was saying, right? Those calls are monitored. They're monitored. They can use that information. What they cannot do is go in and take pictures of his notes and then use that information. I have not read the prosecution's response to the bail motion. I've only gotten through the defense's actual bail motion. I would like to see what it says in there. Are they actually using this information as support of the witness tampering, or are they using the phone calls and emails? The phone calls and the emails are fine. They're fair game. He is using other people's logins and he's doing three-way calls. Those are being monitored, okay? If he's just on the unmonitored line with his attorneys, they cannot use that information. But if he's breaking rules, he's basically waiving his right to privilege information. So I would like to see if they actually use these notes or not, or if the defense is like, oh, well, they saw these notes and that made them look into the phone calls. I don't really know what the positions are right now. So let's jump back into that. So let's see. In support, the government cited excerpts of portions of the photograph. Oh, they just told us. They did cite excerpts of portions of the photographs that discussed that the defendant paying a potential witness and blank on the potential victims and witnesses, which had been provided to the government after review by the government's filter team. So they did receive photographs that talked about paying a potential witness, but it's unclear whether that witness was actually named. The defense is going to say, well, they told them about their expert witness, and they now have that information. So I'm wondering if that he's going to pay an expert witness. That's normal. He's not paying anybody off if he's paying an expert witness. So I would like to know if that's what they're referring to. And then they blinked out what he's going to do to the other victims and witnesses. And the prosecution is basically saying that those statements were probably obstruction of justice, which, yes, you have attorney-client privilege, but you can't use attorney-client privilege to protect the fact that you're having your attorney or people on the outside commit crimes on behalf of you. You can't wrap that into a bow. This is my attorney, but we planned a murder together. You can't do that. And that's what the prosecutions, it looks like their defense is going to be in using that information within their response. And again, I don't know exactly what part of the information they used in their response and what it said, because I haven't gotten through that one yet, but we are going to talk about that tomorrow. We're going to talk about it tomorrow. So let's jump back into it. Let's see. Both experts are consistent with other evidence discussed in the government's submission. So basically, they got phone calls hearing that he's planning on tampering with witnesses, and then the information that they use from the photographs support the phone calls and emails, is what I'm assuming they're arguing here. On November 18, 2024, defense counsel submitted a letter motion to the court arguing that the government was in possession of attorney-client privilege material, namely portions of the photographs which reflected the defendant's notes, which it argued were privileged notes to his lawyers concerning defense witness and defense strategies. The defense also argued that the government had engaged in a targeted seizure of the defendant's material, which it argued amounted to a violation of the defendant's constitutional rights. The defense therefore requested that the court hold a hearing to assess, among other things, who authorized a search of Mr. Combs' cell, determine which material should be seized, and provided the material to the government. As discussed herein, there was no targeted seizure of the defendant, and the BOP sweep resulting in the government's obtaining the photographs was not unconstitutional nor improper. And so then they go into the law that supports their argument. He's in jail. His right to privacy is minimum at best. They're allowed to do the sweeps. He doesn't get special treatment because he decides to write in notebooks about what he talks about with his attorney. The investigator was on the case. They didn't assign them to the case. He took pictures of what he thought was reasonable, and no one really told him what to take pictures of. When he took the pictures, it then went to the filter team, and then the filter team was able to go through it. The raid was not at their direction, and so the prosecution is like, well, we didn't do anything wrong. We didn't give them the information because we planned on giving them the information ahead of the bail hearing, but now they're following this ex parte to get the information early on. So prosecution's position is we did nothing wrong. This was normal and routine. Defendant Combs is a bad boy because he's still talking about tampering with witnesses and obstructing justice. And the notes that we use in our brief supports what we found on the phone calls and the emails. That's my interpretation of everything. Let me know if y'all agree or if you don't agree. And then we get into the defendant's sassy response. Let's go ahead and jump right into it. And then we're going to jump into the chat. So if you guys are watching live or on the replay, make sure you guys are dropping in the chats, in the comments, what you think about the case. And if you're new here, make sure to subscribe. And also, we are like 30 minutes in, and I have never said, please do hit the like button if you haven't already. We're at 17 likes with 30 people watching live. So I know there's some people in here that has not hit the like button. So please do. It's free. It's free and it supports the channel. So. All right, into the defense's sassy response to the prosecution, basically saying that the prosecution sucks and they're liars. To sum it all up, the defense says prosecution sucks and they're liars. Okay, so let's jump right into it. This is the defense responding to the prosecution's statements and their response to the request for the ex parte. The defense writes this letter in advance of today's hearing in response to the government's letter from yesterday. The government's letter only reinforces the fact that the government has committed an egregious, willful, and harmful breach of the attorney-client privilege and has become privy to defendants and defense counsel's trial strategy, including areas of expert testimony, witness strategy, and other confidential matters. Now, I do not agree with that entire statement. They might now know who the expert witness is and that Diddy has to pay them a certain amount of money. To me, that's not really a big deal because they would have had to disclose the witnesses anyways. The prosecution doesn't have to go or they can't go and then intimidate the expert witness. Like, that's just not going to happen. The expert witness is going to be deposed. That to me is not a big deal. But if Diddy is taking notes on extorting witnesses, yeah, that's not protected by attorney-client privilege. I'm sorry, that's just not protected by attorney-client privilege. Could the prosecution have gone a better way about getting the information and doing the disclosures? I don't know, like the timeline of disclosures and the criminal cases in New York and all of that. But you can't do that. That's illegal. You can't violate rules. You can't violate laws under the guise of, oh, this is attorney-client privilege and work product privilege. Oh my gosh, you guys got the map to where we hid the body. You can't argue that because you drew it as the attorney, right? So let's go ahead and jump into the defense's position. The materials provided to defense counsel. So they're going to tell us what they got. Defense counsel has been provided with 19 pages of material seized from Mr. Combs' locker at the MDC. According to the government, these 19 pages were given to and are in the possession of the trial team, which has already started using these privileged materials to its advantage, including its opposition to bail. Based on the materials provided in Exhibit A, it appears a government investigator took photographs of several different items. These include intact pages from 2 different legal pads, pages of an address book, a ripped out folded over page of a 3rd legal pad, a ripped out page of another legal pad, and a ripped out page from yet a different legal pad, as will be described below. I am not going to go over it. They're basically like, it's different because this one has 3 lines and this one has 45 lines and blah, blah, blah. I'm not going to go through that. I'm just not going to go through it. It bears reminding that these clear written statements of the defendants were not provided to the defense as part of the government's discovery or Brady obligations. Basically, anything that the defendant has written down, they were supposed to turn over, or anything that could support the defendant's case, they have to turn over. If it were not for the fact that the government used portions of these privileged materials in an effort to hold Mr. Combs in jail, we would still never have them or even know about them. And again, y'all, I don't know about the timelines on that or whether they were in any violations. Sounds like they had it for about 2 weeks. I don't know how quickly they are required to turn that over. They go on to say the notes are obviously privilege. And here we go into the absolute language that I talked about earlier. His attorney likes to use this absolute language as if he's just right and no one can basically contradict him at this point. Of the 19 pages provided to counsel, 11 pages are Mr. Combs' notes to and with his lawyers. These notes reflect actual conversations with his attorneys concerning aspects of his trial preparation and efforts to be released on bail. The notes refer to defense counsel by name, include discussions of defense experts and witnesses, and discuss cross-examination and credibility of witnesses and overall defense strategy. Mr. Combs' handwritten notes covering legal strategy are now in the hands of the trial prosecutors, who hope to take advantage of the breach they committed to better prepare for the May 2025 trial, bring new charges, and argue for Mr. Combs' detention. Again, they really haven't given us any information other than who a potential expert witness can be. But like I said, they have to disclose that anyway. So I don't know what advantage they particularly get from that. And like I said, if you're talking about intimidating witnesses or how you're going to get them not to testify, that's not protected by attorney-client privilege. So I would like to see what the notes say, but they sealed everything. So we can't see it. We cannot see Mr. Diddy's handwriting and what he wrote down and what he thinks is going to be important of the case because they sealed it. Mr. Combs keeps his legal materials in his lockers. His notes are in the form of a number of legal pads, several of which the government has photographed, as well as loose pieces of papers on which he makes notes. On top of his legal pads and notes, he has a folder marked legal. Now, this is where we get into the weird explanation. Let me see it. Okay, so let me go back to it because I didn't really highlight this. So remember, he said Mr. Combs keeps his legal materials in his locker. His notes are in the form of several legal pads. On top of the legal pads and notes, he has a folder labeled legal. So remember, he's saying that he keeps his legal information in a locker. But when the prosecution talked about how they came about the information, it was on his bunk, and on his bunk to me means on his bed, right? It's not in the locker where he might normally have it put up and stacked perfectly and maybe wrapped in a rubber band. And he probably can't get rubber bands in jail, but they're describing the setup of how the documents were laid out differently. And I think that's going to play a big part, or did play a big part, in what the court decided to do moving forward. Okay. This is to put anyone on notice. He's saying the folder saying legal on top is to put anyone on notice that everything along with the folder marked legal is exactly what it says. Legal attorney-client materials that he brings to his meetings with his lawyers to prepare his investigative and his trial strategy. When he finishes meetings with his lawyer, he brings his legal materials back to his locker where they are kept with clear warning written on the folder that these are his legal materials. So when investigator one, who we will get into in a minute, saw a manila folder marked legal, this was his cue that all of the legal pads and loose pages of legal pads that accompanied it were Mr. Combs' legal documents. If the warning legal wasn't enough, the notes are obviously legal material that he discusses with his lawyer. They repeatedly refer to his lawyers by name. On the 14th page, he writes, "We can't read it, so we don't know what he writes on the 14th page." He also wrote something else that's blank. It is hard to imagine a more self-evidently privileged conversation than a trial lawyer telling a defendant about a blank and defendant's writing it down in his legal materials because it is so important. I think they were referring to the expert witness that they intend to use. On the same page, Mr. Combs wrote that, another blank extraction. This is Heartland trial strategy for express why can I not read? This is a Heartland trial strategy being expressed in detail in notes of conversation between Combs and his lawyers. The fact that the government investigator, government taint team, so remember what we talked about? The government is referring to the team that reviewed these notes, these photos. They're referring to them as the filter team. Go through it, make sure that there's no attorney-client privilege. If there is, redact it so that the people on the trial team cannot see it, so we cannot use it against them, right? We was calling it a filter team with the prosecution. The defense responds, and they are now calling them the taint team. The team that was supposed to be responsible for removing anything that is attorney-client privilege or maybe work product privilege, anything, remove it. They're calling them the taint team. So he's not playing around here. He thinks that this team that works with the prosecutor basically set them up for failure, which again, you're blaming the taint team. Maybe they need to change the taint team. Or the filter team, whatever you want to call them. Let me know which one you are more in accordance with. Do you think that this team was a filter team, or do you think that it was a taint team along with the defense? But this lawyer is being petty, to say the least. Okay, so let's jump back into it. Okay, so the fact that the government investigator, government taint team, and the entire prosecution team viewed this and still believed they could keep the notes and use them against Mr. Combs is unfathomable. Worse still, that the government took notes directed to his lawyers to blank in preparation of trial, and then used those notes as a basis for claiming that he was attempting to tamper with witnesses is astonishing. Now, sorry y'all didn't show the document. I can see why they're blaming the filter/taint team. I can see why they're blaming them. I can see why they're blaming the prosecutors, because once they saw that, they should say, "Oh gosh, why didn't you guys redact this?" Now, let's warn the defense that we have this information out. They could have done that. But to blame the investigator, he's not going to be trained in what is attorney-client privilege and what is work product privilege. So I don't think blaming the government investigator is proper in this context. I think the filter team and the prosecution are more the ones to be blamed here. So let's see. Worse still, that the government took notes, or I think I already read that one. As discussed above, the notes are replete with discussion of legal strategies between Mr. Combs and his lawyers, all of which should have been obvious to everyone who looked at the notes. Investigator 1, the taint team, and the trial team, they're loving calling him the taint team, or them the taint team, but I, again, do not think that the investigator is responsible here. That the government did not, the next thing that they're claiming, the government did not inform defense counsel that it had Mr. Combs' notes is evidence that the government is acting willfully. As noted, the government did not produce these notes to the defendant's own statements to the defense as part of the discovery obligations. The opening paragraphs of the criminal code require the defendant to disclose defendants with written or recorded statements to the defense. You don't give us a timeline there, though. One would think this would be especially urgent when the written statements at issues are in the form of the defendant's own handwritten notes that were taken from his cell and which reflect a specific conversation with his counsel, but the government did not produce these in discovery. Nor did the government taint team established for precisely this type of situation contact counsel and advise counsel it was in possession of defendant's handwritten notes as part of the hearing and to determine what sanctions is appropriate for this egregious self-evident privilege breach. Defense counsel wants to know exactly how the decision was made and by who to not contact defense counsel when the United States Attorney Office came into possession of these notes. Now, I'm saying that I don't know the timelines, but generally when you do come into contact with privileged information, you need to turn that over immediately and you need to disclose it immediately and basically say, okay, we're destroying it at this point. You don't then go and use it. So although there was no timeline given by the defense, which I think they should have put, you are supposed to immediately turn this information over. I think that would have made their letter a little bit stronger instead of me having to guess and base it on our own rules in California. You are supposed to turn it over immediately. So I do understand their position there. I just think their support and their laws that they're using could be a little stronger in order for people that don't know the rules to be able to say, okay, yeah, that is wrong. If they have to do it immediately, they should have done it immediately, right? The government explanation of how it took these notes is riddled with self-contradiction and lacks of common sense. Now, I don't know, it's kind of strong language in this kind of letter, but they did it and it's there and they kind of got some of their way in the hearing, so I can't really be upset with them about that. The government referred to Investigator 1, whose role in these events isn't as mysterious as it is contradictory. The government states that Investigator 1 was assigned to the BOP to participate in the sweep and that he is not part of the government investigation of the defendant. Yet the government also states that the Investigator 1 has consistently monitored the defendant's communication. The government also states that it has sent grand jury subpoenas and documents requested BOP for the defendant's monitored communications. The letter is silent as to which BOP officials the prosecutors work with in connection with its efforts to secure defendant's monitored communication. To me, it sounds like it was Investigator 1, but they're saying it's not clear. So we'll just leave it at it's not clear. But it would appear that the prosecutors will work with, among others, Investigator 1. I would agree with them on that. Under the circumstances, the hearing should encompass what connection exists between the prosecutor team and Investigator 1. Is Investigator 1 just like this person that works underhandedly with the prosecution? This is what the defense is asking. Second, the government writes that BOP sweep was pre-planned, not in response to any particular threat or intelligence. I don't think that one is like fair to use because they were literally citing the website. So to try to use that against them, I think is wrong, but I could be wrong. They were citing the website. This is why they do the sweeps, not this is, the prosecutor is asserting this and they're gung-ho and you have to listen to the prosecutor. They're literally just reading off of the website. However, the government also writes that there was nothing improper about Investigator 1 taking the photographs because Investigator 1, who had reviewed the defendant's calls and emails, was entirely justified in inspecting the defendant's assigned bunk to recover additional evidence. The government's position is immediately self-contradictory because the review of a particular inmate's calls and emails is intelligence, and because acting on that intelligence in order to conduct a particular search is targeting Combs. I would have to agree with that. The government-owned letter shows that Combs was treated differently from other inmates and that the search of his locker and the removal of his notes was based specifically on the intelligence the Investigator 1 developed from listening to the calls and reading the emails. Now, I would have to agree with that because they said they were doing it to keep the inmates and the staff safe. They weren't saying that they were doing it to keep the witnesses outside of jail safe. So to take pictures of notes, unless it was like notes to hurt someone in jail, I don't really see how that would have been relevant for the particular sweep that they were doing. So I definitely get how the defense is saying, okay, well, they targeted Diddy because they heard these conversations and took it upon themselves to take pictures, and they could have literally did discovery on it versus just taking it, which they had a right to take because he doesn't really have any privacy rights in jail. But also, you didn't do that for anyone else but him. I would have to agree with the defense on that. Although not worded the best, I do see where they're going with it. Third, the BOP sweep was purportedly related to removing contraband at the facility. Let's see. The release goes on to state the combined operation identified and confiscated a number of electronic devices, drugs, and associated paraphernalia and homemade weapons. Yet, Investigator 1 apparently used the sweep as pretext to conduct a targeted seizure of Mr. Combs' handwritten notes about conversations with his lawyers. Tellingly, Investigator 1 did not report that he had identified and confiscated Sean Combs' notes of conversations with his lawyers to supervisors of the multi-agency law enforcement operation. He went straight to the prosecution team. I don't know if we can just assume he went straight to the prosecution team, but that's what they wrote. And like the defense is pointing out, if it was a cell phone, sure. Are we saying that he's sending like pigeon messages to his family? He's writing notes and then sending them? Because there were documents or there were pages that were ripped off of the legal pad. So is he sending notes out when people come and visit him? That might be a better argument for the state than just saying, oh yeah, we found papers and we decided to take pictures of it in this sweep. It doesn't really make sense unless you have reason to believe that he's taking these notes and giving them to people when they come and visit him. Hey, go tell so-and-so that they better not testify or I'm going to beat them up. That would be different versus you're saying they're doing a sweep and they just took pictures of written documents. If he's not using written documents to execute his plan. That's my position. The prosecutors have taken the position that the identification and photographing of Sean Combs' handwritten notes were merely part of a multi-agency sweep to rid the MDC of drugs, electronics, and homemade weapons. And again, papers are not homemade weapons. There are ways of proving such a contention. We can call Investigator 1 to the stand at a factual hearing. A hearing should encompass what else Investigator 1 told the prosecution team about the legal materials he rifled through. At a hearing, we could ask Investigator 1 why he called the trial prosecutors, what contact they had beforehand. How did Investigator 1 know which notes to photograph? Did Investigator 1 photograph any other notes aside from the 19 pages defense counsel was provided with yesterday? What, if any, direction did Investigator 1 have from the agents conducting the pre-planned law enforcement initiative, or was he taking direction from someplace else? Was the prosecution telling him to do these things? And then they go on into the next section and says, the evidence shows there was a law enforcement plot to photograph Mr. Combs' notes, have the taint team not advise counsel, and use these plainly privileged materials to keep Combs in jail and to gain an unfair advantage. They basically say that the taint team or the filter team went through these documents. They actually crossed out some privileged information, but kept other information and the defense basically explains that it could not have been a mere oversight, especially noting down and showing the expert witness that they intended to use. They're basically asking for the hearing to go forward so that they can get more information about what information the state has. And honestly, they ask for the prosecution to basically be recused, and they hire another prosecution team. So let's go ahead and jump into our thoughts. Our thoughts before we get into the chat, y'all. Again, if you have not hit the like button, please do. It does help us out in the algorithm and does help us get more friends on the live stream and on the channel in general. Now, we got the defense asking for a hearing about whether Sean's Diddy Combs, whether his rights were violated, his constitutional rights to privacy were violated, and whether they breached the attorney-client privilege and the work product privilege that would attach because they are preparing for a trial in May 2025. Which I would say notes from your meeting with your lawyer is work product and or attorney-client privilege at that point. Although it's not communication going directly to his lawyer, he's preparing that in preparation of the trial. Prosecution is arguing investigator did nothing wrong. The sweep was completely justified. They basically swept multiple cells and that they took a picture of it. The investigator really didn't have any type of responsibility to determine whether this was attorney-client privilege or not. They had a filter team go through everything and knock out everything that should have been redacted. My question is, who was on this filter team? Because it does sound like some things that may have been privileged did get through. And then the defense turns around and says, no, prosecution, you knew that you were wrong because you redacted some things but kept other things, and then you used it against him in a whole brief, and you really didn't turn it over immediately. You held on it for 2 weeks and didn't tell us about it, and then now you're trying to use it against my client so that he cannot get out of jail. I will have to say that I am on the defense's side in that the pictures of the notes don't really seem to go with the sweep. It does seem like it was motivated, like, oh, hey, yeah, we heard these conversations. Oh, you guys are going to be in there anyways. Why don't you take some pictures of if you see any documents that support what these phone calls are saying, because maybe he's talking in code or whatever it may be, right? Why don't you take the opportunity to do that? I can see where the defense is coming from with that, but I don't think that they have enough information and enough evidence to persuade the court that the prosecution did some type of wrongdoing in collecting that information. One, because they weren't the ones actually in the cell and they can't really control the investigator most likely. And two, I don't know what I was going to say for two. I completely forgot. My brain emptied on me. So I get where the defense is coming from, that the prosecution should not have done that. They shouldn't have gone through the notes. When they got the notes, they definitely should have told the defense about it. And then they should have met and conferred with the defense to determine, okay, well, this is what we think is privilege. This is what we don't think is privilege. And then give it back to them, or whatever it is that they would have decided to do as lawyers to make everything fair here. I do agree with the defendant, the defense on that. But I don't agree that plotting a crime, if that's what was in the notes, we don't know because everything was sealed. But if plotting a crime, i.e. tampering with the witnesses, intimidating the witnesses, paying off witnesses, were included in those notes, those are not considered attorney-client privilege. In addition to the notes being, you know, whether it's attorney-client privilege or not, is he taking that notes on, did he take those notes on his own, or were they actually through the meeting? I don't think that they'll be able to prove that, okay, well, normally this folder is on top of all of the other documents, so you should know that it's legal related, and that's what he takes to visit his attorneys. They're not asking him all of those questions. He didn't even know that the documents were moved, right? He didn't even know that anything was missing. He didn't know that anything was taken pictures of. So for them to assume that the investigator would have known that all of this was legal documents because they were on a legal pad, I think that's a little bit of a stretch, but I do think that the prosecution should have been a little bit more forthcoming and given the information over to them immediately. The court ultimately decided that the prosecution cannot use anything that they found during the raid, or that's attorney-client privilege. So again, it gives you a wide array because the filter team already went through things that they didn't think was attorney-client privilege, but then you got the defense saying, no, actually it is attorney-client privilege. The court just said you can't use any attorney-client privilege information going forward at the hearing. So I don't know exactly if the court told the defense and the prosecution to meet and confer and determine what is attorney-client privilege or not, but we could potentially run into the same issues during the Bell hearing. So the defense asked for a new prosecution team. Didn't happen. Prosecution just can't use attorney-client privilege. We'll see how well that holds up. And I think that's kind of similar to the rulings in the courts that I'm in. I feel like they never want to make a decision anyways. But it's similar to the ruling as far as even the gag order that the defense was trying to get and trying to basically silence anyone and everyone that could potentially have a case against Diddy in the courts. Like, no, I'm not going to do that. Deal with it in your other lawsuits. We're not going to deal with it here. I'll give the generic instructions not to discuss this and not to do press releases with information that has not been released to the public yet. So I think they're going to have a pretty hard time trying to push the court to, get rid of this person and let us do this and let them go free and everything. I think they're going to have a really hard time if they're going to keep pushing the case like that instead of focusing on their strategy and getting through the terabytes and terabytes and terabytes of evidence that they have to go through. Focus on the case. Should they have done it? Probably not. It sounds like the prosecution might be getting a little sloppy here, but I don't know. Tomorrow we are going to be talking about the Bell hearing and a little bit more information on what the prosecution actually put in their brief that kind of triggered this abrupt reaction from the defense. Remember, the prosecution filed their brief last Friday at nighttime. And then here we got the defense filing an emergency hearing immediately on Monday. So they were probably working on that all weekend, that 3-page letter. I hope that wasn't all weekend because there was a lot of typos in it. I struggled through it. But anyway, not typos, but just poor sentence structure. Yeah. Anyways, we'll talk about the Bell hearing tomorrow. Let's go ahead and jump into the comments to see what y'all have to say. All right. And so we are going all the way from the beginning of the chat. We got Kayla Eloisa, member of the channel. Welcome in, saying hi, hello. Nice to have you in tonight. We had Cheryl Reed saying hello, Bree. Good to see you this evening. Hello and good to see you. I am trying to stream more often. I've talked about this on other lives because I can't edit. So we're just going to live stream things. So we can get the information. We got Crystal Harris saying live in the hive. Hello and welcome in. Cheryl Reed saying, I heard a little bit about the new bond request, but not the raid. Yeah. So the raid was actually almost 3 weeks ago. And I didn't hear about this previously. So we're just now hearing about it. And apparently some information came out of it. And that's why we're here at the emergency request today. Island said, hey, BriHive, hello and welcome in. We got Cheryl Reed saying something seems a little shady. In my opinion, Diddy should receive a fair trial. No shady business from the prosecution. It does seem like something is shady here. I would have to agree with you. I think the defense is right that they should not have used this as an opportunity to take pictures of his notes, unless there was some type of indication, some type of evidence, something said on the phone of like, oh, when you come, I'm gonna give you the list of the witnesses I need you to beat up. That would be something different. But if there was nothing on the phone calls that indicated that he was writing things and handing it to people that were coming to visit him, I don't see why taking pictures of his notebooks would have been around the overall safety of the prison. And even if he was writing about, beating people up in his notes and handing it to someone, I don't even know if that would, benefit the overall safety of the prisoners and the staff. That's for people outside of the jail cell. And that raid was not for that, right? So there's that. We got Chris Mullen, member of the channel. Hello and welcome in, saying hey, Bree and everyone. Hello. Dropping some of the membership emojis. Love to see it. MG Mustang 05 says federal prosecutors are on a whole different level than the state. When the feds file charges, they are already prepared to go to trial. It's the defense that plays catch up. And they are playing catch up. And I think they should really focus on the actual trial instead of doing all of this. But also, I do think think that they had a point in filing this motion. Like Cheryl said, no shady business. It does seem like there's some shady business here. I do think that the prosecutor is ready to go forward on these charges. What I don't think they're ready for is all the other charges that they really need to be bringing against Diddy. They talk about they were going to bring witness tampering charges. They're talking about there's other victims. Like, when are we going to get to that point? The trial is in 6 months. Like, what is going on? MG Mustang 05 says the dealer will never see light of day and he'll be sued out of his assets. Yeah, there's already so many lawsuits. We've covered a lot of them on this channel and we haven't even touched the surface of it, I feel like. Crystal Harris says, uh-oh, where'd she go? Yeah, I kicked myself off. I did kick myself off. Phoenix Waller says 11:29 at night, so Bree decided just to go to bed. I am tired, y'all. I'm just like still trying to shake back from Miami and like just getting, back on the right time zone. So maybe that's what it is. Because someone laughing, Sherry laughing. I literally kicked myself out. I hit some button on my mouse that backed me out of the screen. So I apologize. Chris Mullen says the defense clutching at straws. They are and they're not. Like, I do think they're right. There was some type of wrongness in what the prosecution did. Did it call for an ex parte hearing? In my opinion, no. I feel like it just gave the prosecution more time to reiterate why they think Diddy is a bad guy. MG Mustang 05 says the allegations of him having 3-ways with his mother is freaking hilarious. Him and R. Kelly are gonna make great cellmates. And I'm just like, why are you doing the 3-way calls? Like, you're telling the court I should be able to get out because I am an upstanding citizen, and then you turn around and then you break all the rules. Like, you've only been in jail for what, 2 months at this point, and you're already breaking all the rules. Like, it makes no sense. I'm not going to tamper with witnesses when I go. Yes, you are. Yeah, you definitely are going to contact them. And we'll get into the bail motion, but he basically says, yeah, me reaching out to witnesses to help prepare for my case, that's not tampering with them. That's not tampering with them. I'm sorry, Diddy. I don't think you're just gonna reach out. I don't believe that one. Sorry, I'm sorry. Sandy says, "Hey, all, hello and welcome in." Eloy saying, "Hi, you all, hello and welcome in." Jesse says, "Hi, Bree in chat, hello, hello." Everyone saying hi at the end of the stream. Because Mama saying Bree cracking up. Don't remember what I said. Jesse G says another prosecution team. Yeah, they wanted another prosecution team. They're not doing that at this point. Maybe if they keep messing up, I don't think they've messed up that bad. I feel like they can hide the wrongness in what they did because the investigator doesn't know. He's not going to be privy to what's attorney-client privilege and what they need. Do I think they should have asked the court to search his cell because they think that he's tampering with witnesses? That would have been a reason to take pictures of notes and do what they needed to do. But just, on a regular raid looking for shanks, that was pushing it. It was pushing it. Chris Mullen says this seems to be something the prosecution pulls a lot on defendants. I wouldn't be surprised. They were able to explain it away pretty immediately. Oh no, this was already planned. They do like routine searches all the time. We just, read their diaries. Like, you can't do that. You cannot do that. Because Melissa said, hey. Just Stacy says, I love how that spell. Hi everyone, hello and welcome in. Stargazer Kawaii says, why am I always catching the streams late? I don't know. I posted this one kind of late, like around 5:30, so that could be a reason. It was only up to 2 hours before I went live. But tomorrow, like I said, we are going to be covering the actual bail motion, the bail response, and we should have a bail rebuttal from the defense as well tomorrow. That's when the deadline is. So hopefully it will come out before we actually start the live stream. And then we will go from there, y'all. There has been some pretty interesting cases coming out. We got a couple of copyright lawsuits. Got Meg Thee Stallion being sued. Plies is suing someone. Well, let me see which ones we got. So I'm trying to stream pretty much like every weekday, but I don't know if I'm gonna be able to commit to that all the way, y'all. I would love to, but I don't know if I'm going to be able to. We got Kanye West being sued by another employee and being racist to Jewish people. We got another lawsuit that I spent 2 hours trying to find and I couldn't find. That wasted $6 trying to find this lawsuit for y'all. a lawsuit against Tony Busby. Anthony Busby, the one that's representing the alleged 120 victims of Diddy. He's already filed like 15 of the lawsuits. We covered it on a live stream, I think last week or the week before, the new lawsuits that he filed. He and his law firm is being sued by a high-profile celebrity. They haven't told us who it is. It's John. They're going under John Doe. I searched the LA court system high and low and could not find this case. Okay, y'all. So I don't know if it's just, hasn't been filed yet, or he's still being approved by the court, because he is trying to file under anonymous name, and they submitted it to the court yesterday, but they're saying it was filed on Monday. It is absolutely not filed. It's not on LA court system. It did come out under TMZ. So once it is available, if it ever becomes available, it looks like Tony has already responded to it. But I think TMZ kind of broke the news, which can happen when they know it's going to be a high profile case. They might leak the document to a news outlet to kind of start getting the word out for everyone. But what I can say, it is not, unless I just suck at searching. I spent $6 searching, so I better not suck at searching. It is not on the LA County website, so I don't think it's actually, processed with the court yet. But once it becomes processed, we can check that case out. Basically being sued, basically saying that the attorney is trying to extort him, just like he's extorted other celebrities, basically asking for a lot of money to settle the lawsuit. I would love to know who the high profile celebrity is. I got my hunch of who I think it is, but again, I don't even have a lot of information because I couldn't find the actual complaint, and I'm definitely not relying on TMZ for my information. Okay. We got somebody sued, Anthony Barre is suing Beyonce, but I forgot for what. For what. And then someone is suing Angelina Jolie for allegedly practicing witchcraft on her. I can't remember if that's the old one or if it's a new one. And then there are some other lawsuits that I am planning on covering. Maybe there'll be shorts or very, very short live streams, and that I'm going to break up. But we got a couple of things to get through. Like I said, Plies is suing Megan Thee Stallion, Glorilla, and Soulja Boy for copyright infringement. We're going to cover that one. I just got to find a different time to go ahead and cover it. Let's see here. And I'm just going to cover a couple more chats, and then we're going to get out of here, y'all. Stargazer Kawaii says he does have a record of witness intimidation, doesn't he? That's what they're saying, but a lot of the times they weren't cases that were actually filed, like criminal charges against him. So can we call it witness tampering? I don't know. I don't know if we can call it a history of it, because he didn't have any criminal charges. But a lot of people are saying he intimidated them, and that's why they never came forward before. Stargazer Kawaii says, on a completely different note, the tiger tee is tiger shirt is cute. Thank you very much. I got this like for free at I got this for free at my college, and I'm gonna show it to y'all. It's supposed to be tiny or what is it, Tony the Tiger? Because it's Kellogg's, right? But that does not look like Tony the Tiger. This shirt is so old, you can see it all cracking. Does not look like Tony the Tiger from Frosted Flakes. I did go to HBCU, so we was calling him Tyrone the Tiger because it's not Tony the Tiger. It's really not. But yeah, thank you for the compliment. Phoenix Wallace says, at least it'll be real witness intimidation. If he doesn't, not a bunch of rubber duckies. Yeah, and they're like trying to preemptively stop it. Like, let him do it and then come after him. Don't try to catch his boat messages or his pigeon messages to his family members. And I just don't know how they're gonna find that it's supported. But anyways, no new prosecution team. I feel like they still didn't find out nothing that they wanted to find out, and we'll see what kind of information gets let in at the bail hearing. That will be on Friday. We are covering the bail motions tomorrow, and then we'll go into some of the newer lawsuits or other lawsuits that we have not been having time to touch base on. But anyways, y'all, I'm tired. I have to go back to work tomorrow, and I really don't want to, and I think I am getting sick. That's not a fun time. So anyways, I hope everyone has a good night. I will see y'all all on